Thanks everyone for joining us today. Welcome to Integrating AI into Transactional Clinics Tools and Strategies workshop, which is presented on behalf of the AALS Teaching Methodologies Committee. Today is Friday the 13th, which feels kind of appropriate for this discussion. I'm Catherine Hughes. I'm Director of Fordham Law's Entrepreneurial Law Clinic, and today I'm joined by Daryl Motley from Suffolk University and George Contreras from the University of Utah, as well as a number of additional lightning round presenters. Today's session is being recorded, and so that you can participate at the end, we've organized this as a regular Zoom call. As such, we ask that you be mindful and mute your microphones throughout unless you're called on to speak at the end. We're also happy to share slides to participants and other materials after the talk. Our goals today are practical. We're going to provide a brief AI overview and share clinic-ready ways to use AI in teaching and in client work while keeping pedagogical goals, ethics, and professionalism always in view. I'll kick us off with a short AI overview to level set and then discuss how I've been approaching AI use in my clinic. After that, I'll turn it over to Daryl and George for their case studies. Then we'll do a lightning round of 4 quick takes on what our colleagues are trying across the country. Then we'll end with some discussion. Just a caveat, we're at the beginning of this, everyone is, so we're sharing what we know, what we're learning, and what we've been experimenting with, and the mistakes that we and our students have been learning from. And it's all changing so quickly. What's helpful today might be completely different in a few months or really even a few weeks. So we look forward to learning from you. I want to start with the AI overview I've been sharing with my clinic students. To me, it's really important that the students have a solid understanding of the tools they're using before they even begin to consider using them for client work. This will help them understand the risks and formulate an approach for how these tools can be useful. Before we get into use cases, here's the one thing that we want you to keep in mind. Most generative AI is prediction, it's not search. So these systems are trained on massive amounts of text by repeatedly predicting what comes next, which makes them great at drafts, at summaries, and organizing information. But prediction isn't legal judgment, as we all know, and it isn't a guarantee of accuracy, currency, or fit. We also can't assume that the AI is actually looking things up for us in real sources unless the tool is explicitly connected to a retrieval function. So you need to understand the tools that you're using. So with that framework in place, I'm going to define a few core terms and review the 2 key weaknesses that we reliably expect. In my clinic, we treat AI output as just a starting point. It comes after our own brainstorming and outlining, etc. And then we review it for authority and accuracy, fit to the client's facts and goals, tone and strategy, confidentiality concerns, and we weigh the overall risks. So that we're all on the same page, let's review the few key terms. So for core building blocks, generative AI, it's the broad category of systems that create new content, including text, images, code, or audio. The LLM, or the large language model, is a type of generative AI that's designed to understand and generate language. ChatGPT, Claude, and Gemini are products that provide an interface to one or more LLMs. For example, today I'm using Claude on the Sonnet 4.5 model. Harvey is a workflow platform that's built on the LLMs, and depending on the configuration, it can connect to research content, for example, via LexisNexis to support citation-backed outputs. Spellbook is a comparable Word integrated tool that's focused on document drafting and review. An agent is when the system, not the user, can plan and carry out a multi-step task using tools and iterating toward a goal with human oversight. Prompt is the instructions that you give the system. Good prompts specify the role, the task, key facts, constraints, and the format that you want. Context is what the model can see when it responds to you. Your prompt, your prior messages, any documents that you might provide. The context window is the limit on how much AI can consider at once. In clinic work, context is really where we encounter confidentiality risks. And the 2 key common failures that we see are 1, hallucinations. You're all probably familiar with this. It's when the tool produces false or unsupported information with confidence, such as fake citations, invented statutes, or made up facts. And omission. I think people aren't talking about omission enough, but you need to watch for omission, false completeness. The model may leave out key issues, edge cases, or follow-up questions, and it may also make choices that are inappropriate for the client's situation or our role. So we verify what it says, we audit what it does not say using checklists or counterprompts and further research. So here's how these pieces fit together in practice. You interact with an underlying LLM through a platform like ChatGPT, Claude, Gemini, or a legal tool like Harvey or Spellbook. The model generates content by predicting text based on its training and the context that you provide. If the platform has agent-style workflow enabled, it can also run a multi-step process, breaking the task into steps, applying a repeatable method, using tools like document search or comparison, and then iterating with you. Here's a concrete example. Imagine a diligence task. You tell the AI to review 50 customer contracts and flag deviations from the standard the clinic is using. The model helps extract and compare language. The platform manages the documents and the outputs, and an agent workflow, if that's enabled, can run the steps contract by contract and then compile a report at the end. But we still need to treat that report as a starting point. Users need to spot check flagged items in the source text, run an omissions checklist, and apply legal judgment about what's material and how to advise the client. For prompting, I'm primarily teaching my students a really simple approach that's fairly intuitive. First, we start with a clear assignment. Say who you are, who the AI is, what you want, for whom, and in what format. That is really the difference between saying, draft me a vendor agreement, and I'm a very smart 3L law student counseling a low-income small business client. I want you to draft a vendor agreement for his wedding catering business in plain English with notes to him explaining how this agreement can be modified. You need to add key facts and constraints, jurisdiction, deal timeline, client goals, what must be included, what must be avoided. If you leave gaps, the tool will fill them for you. That is obviously not ideal. You want to specify the output format, headings, bullet points, table, red line suggestions. And I really want to note, AI still gets tired sometimes. You can help it stay engaged with you and your interactions by breaking assignments into smaller steps. Fourth, you need to understand the tools that are available in the platform, whether it's retrieving sources, whether it can search online, or whether it can only generate textual changes. Fifth, just use the tool as a brainstorming partner. That allows you to explore more pathways. Then you use any output as the teaching opportunity. Students then show you their prompts, review the output, and defend their choices. They need to demonstrate that they are reviewing authoritative sources, and then they will revise the material based on your supervision. And finally, treat prompting like you do deal drafting. It's iterative, it's not one and done. If the first output is weak, tighten the prompt and rerun it. For anything significant, definitely run the prompt multiple times, and sometimes you're going to want to run it across different tools to see whether the output is stable or if it's drifting. We also cover verification essentials in the clinic. So these tools include, as I've said repeatedly, treat the output as a draft, not as authority, even when it comes across sounding very polished. Build verification into the workflow of your project. Students will want to ask the AI to do a second pass every single time. Ask it to double check for accuracy and completeness, list out its assumptions, and cite where it's getting each point from. And for anything meaningful, run multiple inquiries. Rerun the prompt, compare across tools. Any instability you see in the responses is a major signal that the students need to dig in further. And of course, always verify against primary sources. Throughout these exercises, students need to exercise data discipline, minimize what they input, anonymize when they can, and don't upload sensitive or confidential information into unapproved tools. This slide covers the guardrails: confidentiality, privilege, verification, and professional responsibility. This is the framework that I want my students bringing into every AI interaction. First, confidentiality. We do not enter client identifying or sensitive information unless the tool is approved for it. And so far, none of these tools are approved in my clinic. Maybe Harvey will be once they get access to it, maybe on a limited basis. We minimize and anonymize inputs, and we assume anything pasted in could be retained or exposed. So we limit inputs to what is really necessary, and we use generalized facts when we can. Second, privilege and work product. AI use can complicate privilege and work product. That's a space that is still evolving, especially when information ends up in an environment that's shared, retained, or later discoverable. So we want to use protected channels when possible, and we treat prompts and outputs as potentially discoverable drafts. Finally, AI doesn't change our duties of competence, supervision, confidentiality, or candor. We document use where appropriate. We apply independent legal judgment to the final work product. I review these guardrails with the students at the start of and throughout the semester. We have a lot of discussions about them. So we wanted to share with you a high-level landscape of how transactional lawyers are using AI right now, mostly to find, summarize, and scan, maybe sometimes to draft. Across these categories, precedent banks, research, contract review, meeting notes, diligence, negotiation prep, automation, translation, the real common pattern is that AI is most useful for first pass work, organizing and brainstorming, maybe beginning drafting. I'm asking my students to start on their own. Don't just jump to AI. I want them to share with me a traditionally researched issues list or a potential term sheet before they start iterating with AI. We review that document together, and then we start to think about how AI can help deepen their understanding and help them to identify any missing pieces and next steps. So a little bit about me. I'm starting in the clinical space after about 15 years in big law, and many of my students are headed to big law. So that's really the lens through which I'm viewing this. In that world, the mantra I kept hearing was AI in everything we do. And what that meant wasn't use ChatGPT for a few discrete tasks. It was move past one-off use cases and start rethinking workflows. What can be standardized? What can be done faster and more consistently? And where humans should spend their time. I'll admit that my reaction to this was that it all felt a bit scary and that it also felt super hypey. But as I've explored more, I found that so much has changed even in the last year that sometimes my own imagination is really the limiting factor here, not the technology. To me, avoiding AI would be like saying, we'll only use a computer to type final versions of contracts. It's just not efficient and it's not realistic. So I am constantly asking myself, how can I teach my students to be critical thinkers, to learn the law, and to consider where humans will still add value in the years to come? And to be honest, I am pushing on live presentation skills, on relationship building, on collaboration, counseling through ambiguity, creative problem solving, ethical judgment, and really human-centric opportunities, while fostering curiosity about the law, our clients, and the institutions that they're navigating, and how we can get accurate results while using these tools to expand our work and access to justice. In my clinic, I'm currently approaching AI through 3 buckets: our AI policy and procedures, skill building and inquiry through our seminar sessions, and fieldwork discussion and implementation. First, our written policy. We treat AI as the starting point. Students should share with me how they prompted, at least for meaningful uses. And the rule of thumb is first brainstorm, do the research, draft the issues list, share that work with me, and we then discuss how best to use the tools to identify what they've missed or how to start next steps. Second, in my seminar skills classes, I'm bringing in our law librarian to teach the tools we already have available to the students. We've also had big law innovation teams come in to cover the basics, how to prompt to get better outputs, how different versions of the core models behave. We look at LLM ranking models like LM Arena, and we discuss why it matters whether a tool has retrieval capability or is just generating. I've also incorporated a session on the environmental, social, and racial justice issues around AI and data centers, including video and discussion about how data centers are affecting communities and our natural world, discussion of who is and is not designing and managing the LLMs and the various end user products, who has access to these tools and who does not, and how we anticipate the profession will be affected. And then third, in my field work, the clinic serves primarily low-income small business owners. We acknowledge the reality that our clients are already using AI, and they're not always doing it responsibly or effectively. There simply just aren't enough transactional lawyers available on the timeline our clients need and at a price they can afford, so this is their last resort. We've been partnering with local incubators to teach AI safety to small businesses and nonprofits, and we're working on educational materials and workshops. What are the red flags? When do you escalate to a lawyer, and when might AI be okay to help you? On the student side, they've used AI to translate legalese into plain English, identify weak spots in contracts, and outline the steps in a transaction. But they have to be able to defend their strategy or any AI-introduced edits. They have to be able to confirm their sources, and then they revise based on our supervisory conversations. I've also been using AI to help prep hypos for class and talking points for presentations. So far, AI is pretty good at the former. It's not very good at the latter. It's been a really iterative process. Our students will be getting, at our school, will be getting access to Harvey later this semester. I will encourage them to experiment with it, see how helpful it is. The same is true with Spellbook. I haven't even used Spellbook yet. But I just did want to say that my students are, I just had a student submit this morning a reflection paper on a mistake that happened when she used AI, and she reported to the class that something was true when in fact it was not. and that it was a really important learning point for her. So I'm pretty excited that she experienced that she can now see the flaws in it. So encourage that discussion. With that, I'll turn it over to Daryl, who's going to dig into the weeds on his specific projects.
Okay. Thank you, Catherine. That was a very good summary as well. Let's go to the next slide that you're running in. So I'm gonna talk about this sort of more of a pilot project I'm working on with my students. It's I call it generative AI, and it's a client interview trainer pilot project. It is for students that are brand new in the semester, and we're first week or so, we're trying to learn how to interview skills and the pedagogy issues. And the thought is to get them more additional supplemental training into interviewing clients and to reduce sort of the anxiety that they all have about talking to a client as well and help them. So this is, if you will, broadly, this is sort of the flight simulator analogy for clinical pedagogy training. So let's go to the next slide, Catherine. I don't know if it moved or not. Okay, yes. So the concepts are kind of, this is sort of broad, theoretical, broader concept that I have here. The clinical pedagogy issue is a client interview skills development for the students. And then as we do it through the class, we talk about the T funnel method of getting client information and going through the analysis, and they're kind of getting information out from the student, from the client in general. So I'm using this more where the AI avatar is for the interaction component, and it responds verbally to verbal input, and the avatar moves and talks in real time through this process. So on a doctrinal side, I'm adding in, create on a theoretical database, which I'll talk about, the knowledge database. I'm using new legal realism concepts and law and action kind of aspects, kind of create the hypo thinking about it. Then I want to add in an IP issue property. So I'm looking at trademark law can be part of this analysis, patent law. There may be an immigration component. We don't handle immigration, so if we get to that level of analysis, the students would be knowing that we need to refer that to another clinic. This is all hypothetical facts. So, and there's also a business issue. So I have most of these kind of broader high topics in the hypo conceptually. So when they go through the analysis of the questions, we'll see kind of where they go, and this is a knowledge-based input into this AI system, completely use case. So I think the next slide would be helpful to show. Yeah. So this is kind of the theoretical and knowledge base into the system. So this is more for what the system will take input in and create its model that I'm going to use for them to analyze the questions from. I use a system through my clinic called StoryDoc that creates these nice pitch decks and different things using some generative AI technology, templates, and so it feels like a real case, but no one really has pitch decks to bring in. But it has data that they can kind of see and use, and it's live information. I take that and then input that into the system. I have a fact pattern, hypo fact pattern. I have an individual. They're born in another country. They're I think Sweden. They moved to Massachusetts. They as a young age, and maybe undocumented, and they found out about that later. But it's in the pitch. It's in the deck issue. They did really well in school, and they have this new culinary invention that they want to come with thoughts and what different things I put in there. So they have created this company called Spinghetti, let's say, and it may be like a trademark. I'm not sure. So it's in this hypothetical fact pattern, but the students don't see this. So it looks like we're doing a IP consult. So typical some IP boutique firms, maybe somebody comes in and they have an idea. You might do a conflict check and you say, okay, but we're not. They don't want to tell you everything what they want to do. So you just the students are literally going to come in, or attorney will come in and ask, okay, what did you need to do? So this is sort of this process where they don't know the subject matter, but they know there's somebody coming in, and this avatar is that kind of simulation. If we go to the next slide, Catherine, we'll show you a little bit. So this is, I'm sure everybody's familiar with this general T funnel method. The four boxes, the client greeting, it kind of work in the AI context. So I'll explain a little bit what that is. They can kind of ask preliminary matters about kind of what they're looking to do. And then I'm focusing on the problem ID and the detailed fact gathering for the students, kind of get them the process, trying to get used to this process of interviewing client and getting information. The theory development and counseling, that's not part of this. It's not going to be ever counseling and AI systems. I hope we don't get to that. So we'll see to do that. But on preliminary matters, problem definition, and detailed fact gathering, I want them to kind of do that. We do that already for live humans, myself, or maybe role playing early on, so they can kind of get used to that process for the early stage system. So I think the next slide is more the AI agent. Yes. So this is just I'm showing a little bit how we do the AI setup. This is DID Studio kind of system. No programming necessary, although if you want to program, it's probably something else. This is a system where I can say I want it to stay within the database information I set. That's what grounded they call that as well. And then in the knowledge base, I can upload different files, up to text. You can put to 80,000 characters, which I think is about 50 pages of data if you want of text in there. So input all this information in. Then I set sort of this slider of the creativity, can kind of add, just can kind of take data outside of that and think about what it wants to do. And there is an LLM model that it can use, and this is the ChatGPT o4. I think o4 is going away eventually, but the models are sort of provide some personality that these models have, feeling more human-like, I guess is what they do. This is the agent 1.0. This system, there's an agent 2.0 that has even more lifelike, where the agent moves, talks, speaks in real time with it's on your basic laptop on the web as well. So this is the setting issue. You put it in, and then it creates this small model, and then we can interact with it on a verbal basis and come back. So I'm going to go to the next slide, Catherine. We'll see. So here's a kind of an in-class demo, at least a screenshot of that. I don't have a clip to show you at this stage, but I can show one later, but talked about it. So it's on the screen, on a laptop screen. Students ask the questions. The computer system will literally process it verbally and talk back. Now, some folks have used ChatGPT or Perplexity in a verbal context back and forth. This one kind of takes a step further than that and puts it in an avatar, moving, talking back and forth, and it puts the information up on the screen as the students will speak. So I wanted to just give you a little bit of a conversation. It records the conversation and puts it in the system, kind of a transcript. Then I can also evaluate the kind of the topics on the back end as well. But I think next I will show you sort of a conversation. So this is a kind of a conversation. The black boxes are the black clouds are the ones the students actually ask verbally, and then they gone through some of the questions as well. This sort of in time, they sort of going through an invention disclosure meeting or discussion. What other stringy foods is this good used for, and it's actually answers a question from the data system with not exactly what I put in, but it says it's good for spaghetti, but also fettuccine and linguine, even noodles. This is the LLM doing it as well, and then it talks about innovative design, makes it enjoyable for eating pasta, and it has a kind of need for information. Or this is the agent talking about it. So that's the first question. Then you go up to the top. The compound question the student asks is like, well, how did you come up with an invention, or did anybody else we work with? Now, I don't like the compound questions. I like to kind of go simple, easy, but the system comes back and kind of iterates the previous conversation, but then says spaghetti is good for this, but it says, through the invention process, I developed the concept of I can't totally read my brain here. Tables of friends, and I use friends and families and with brainstorming and prototyping. LLM is doing this verbally, and then sort of this T funnel method. It says friends and families is what they said. So a student asks, "Oh, what did you get from your friends?" From the conversation, the system responds back, almost like a human would say, "Oh, well, I collaborated with a team of people to do this and using gastronomy technology." That's not in the system. I didn't put that in, but the LLM is kind of doing it. So you kind of get a feel for sort of the students and the back and forth about how you can kind of converse back with the real client potentially. But this is just kind of on the fly for the students to kind of get used to the training to do that. So if we go to the next slide, Catherine, I'll give you a little bit more. So student comments, they have said this, and this is actually, they said it could be helpful for a trial run, trial practice, but as they reminded me, no client information put in a generative AI system. You can't simulate a real client that you actually know is coming in. It's good for just kind of getting used to training and doing it. It could also help with test questions, maybe if you're going to get unexpected answers, because I do kind of like the hallucination answers because you never know what a client's going to say all the time. It's not textbook, right? The written hypos they're there, they can read, but this is sort of takes the written hypos to a different level, if you will. It will. There's new Agent 2.0 makes it more natural as well, and then they say it feels robotic and it doesn't give all the answers. I do have a skeptical student, a doubting student that says it doesn't. It just not exactly it pulls data, of which we know predictive algorithm. But I have to say this: we did another test before the Super Bowl, a week before the Super Bowl, and the doubting student just asked Seahawks or Patriots. Well, the system responded, said, I like inventions, I like inventions as well, but I am passionate for football. So I was like, that's not in my hypo, but at least the system kind of did a neutral response to where it is. So there's some benefit to being slightly human aspect as well. So if we go to the last slide I have generally on this issue, the students suggest like more form. If we do more, this is training, kind of testing, piloting. So it says like for next year, more formality. We'll test for formal. We'll change hypo some, but we'll give the students more of a topic. You're gonna you're gonna work on one topic and then the other topic, and so they can funnel down more down into the questions. So this is an idea that to help get students additional input if they to train before they get a client. After they get a client, there's not any use for this, but it's before they do this, it might be helpful to do this. So that concludes my talk on this. Thank you.
Thanks, Daryl. Let's see. Okay, next up, George Contreras from the University of Utah.
Great. Thanks so much, Catherine, for organizing this and giving me the opportunity to share some, very new experimental work that I've been doing in my classroom as well. So, by way of explanation, I am the faculty director of our new IP clinic, which was just certified by the USPTO this year for patent and trademark prosecution work. But my focus of this talk will be on a class that I'm teaching in IP transactions, which I've taught for many years. I too come from a big law background. I was a transactional lawyer. I have a case book on intellectual property transactions that I have used in past years when I've taught this as a doctrinal course. This year, I have really introduced a significant skills element to the course that is focused on using AI contracting tools. Okay, so we can advance to the first slide. So, as you know, I won't go into the technical details, and Catherine did a great job of summarizing those at the beginning. But in I think the view of most people looking at this really all started in the fall of 2022. For years before this, we had machine learning, we had natural language processing algorithms that were useful in the legal practice, primarily around document review and legal research. But the natural language, conversational LLMs like ChatGPT really opened the door for contract generation tasks, right? And so, in addition to the general purpose LLMs like ChatGPT and Claude and Gemini, there is a set of fine-tuned legal LLMs that run off of GPT engines, but are secure. Allegedly, they operate in walled gardens. Law firms, in particular, can input and upload their entire precedent database to be used for contracting tasks. And so, in a research project that I did last year, that's resulted in a paper that was up on SSRN at this point, we interviewed a bunch of lawyers in-house at companies and at large law firms who were using these tools, and also at some of the vendors of these products, to get an understanding, or try to get an understanding, of how practitioners in the field were using AI tools, particularly in contracting tasks, right? Because that's really what my practice focus and my teaching focus has been on. And so, to the next slide. And by the way, many, if not all, of my illustrations in this presentation were in fact generated by Gen AI programs, which is why this earnest looking lawyer's laptop is sideways and his arm is like on top of the keyboard, and it's not really clear why he's got a gavel on his desk, but there you go. So, and actually, Catherine, why don't you just click through? There's a bunch of animation here. Let's click through to the bottom. There are a couple of points under negotiation. So these are the three categories of tasks that Gen AI is being used for in the contracting and transactional world, right? Drafting contracts, review of contracts that are received from the other side, and then the active negotiation of contracts with the other side. You know, Outside of the educational world, where lawyers are dealing with contracts that are lengthy and complex and interrelated, Gen AI just is not capable of generating an entire draft, right? We've seen, like Catherine described some, Dan Schwartz and his colleagues have done numerous experiments using Gen AI programs for like the trivial little contract, like draft a contract to paint your neighbor's house. That's great. But real lawyers and real law firms aren't doing a lot of that work. It's a 75-page, asset purchase agreements for a divisional sale. It's a complex, like patent and know-how, licensing and joint R&D agreement. And the tools that are in existence today are just not good enough to keep all the defined terms consistent, and to make contracts that work as unified wholes beyond the very short example of, like, non-disclosure agreement is the quintessential example of a whole cloth contract that a Gen AI tool can generate. Beyond that, you're taking your chances. But lawyers are using these tools quite a bit to generate clauses. So if I want to generate a clause for a net sales definition in my patent license agreement, I can get a good net sales definition with lots of variants that I can consider. They're also quite good at using templates. So, as I mentioned, law firms can upload a template library into their private walled garden version of a tool like Harvey and then draw on those templates. And so, if I'm, law firm A, and I've got a form of asset purchase agreement, I can instruct my tool to generate an asset purchase agreement, with this term sheet based on my firm's form of asset purchase agreement. And that turns out okay. On the review side, the tools are actually quite good at providing comments on agreements that are proffered by a counterparty. They use their general knowledge, and to a degree, they've been trained on contractual material, which I'll talk about more in a second. Also, very useful is the ability of a tool to ingest a company's contractual playbook, right? Which is the set of contractual terms that a company always agrees to or will never agree to, and what their compromise positions are in between. So, for example, if I'm a large company, I might say I will never indemnify for more than $5 million for like my employees' negligence or intentional harm. Maybe that's due to our liability coverage. Maybe it's due to just an internal policy, or, in confidentiality agreements, I will never agree to a residuals clause in a non-disclosure agreement. Those playbooks, which used to be these, giant 3-ring binders full of all of these rules, can easily be incorporated into your private tools instance so that it can review proffered agreements from counterparties against those playbooks. And also your precedent libraries, libraries of approved forms within the firm, or also just completed agreements and even agreement drafts. And the final component of this is negotiation, redlining, sending over a revised version of a contract with commentary and explanations in the margin. And so one thing I should mention is that these tools work differently. So if you're used to ChatGPT or Claude, you're used to interacting in kind of a window that the tool generates that you type queries into. And as we saw in Daryl's presentation, right, it puts responses into that window. Some of these contracting tools, like Law Insider, which I'll talk about more, they do have that window-based functionality, but they also operate as plugins or add-ins to Microsoft Word, so that you are operating on a large contract in Word while the tool is sort of part of Word. So the tool can do redlining in Word. It can use the commenting features in Word, and that's actually quite useful in generating drafts and the contracts that we actually work with. All right, so we'll go to the next slide. And I think most of us are familiar with what the issues are. So I'll just quickly skip through these, but why don't we go to the next slide? And just click through 3 clicks here on this one. One of the problems with contracts, as opposed to legal research, writing memos for clients, and even writing legal briefs, is with contracts, the input data that is used to train LLMs is lacking. It comes, for the general purpose LLMs, it comes largely from the SEC's Edgar database, which has thousands of contracts, but an incredibly skewed sample of contracts, mostly contracts produced by small companies to whom the contract reaches a materiality threshold requiring its disclosure under the 1934 Act. And so you don't get big company contracts. You'll never see an agreement between IBM and Intel, for example, in the SEC's database. It's startup companies who are just going public, who release those types of agreements. The big companies, there are certain agreements that must be disclosed under the SEC's rules. The building lease, like your real property lease for your headquarters, your employment agreements with key employees. But in terms of like business substance agreements, not many. And then you've got legal forms that have been around for, a couple of centuries. A lot of those are part of the common knowledge, the training sets for LLMs, but they're often outdated and quite sketchy. If you've ever looked through a form book, you wouldn't want to use those forms by and large in a sophisticated agreement. Most of the real contracts are under lock and key. They're confidential. They're still in the law firm databases. And so this is why law firms that are large, especially, have really take advantage of tools like Harvey that can ingest and train on, 5,000 examples that are in their firm's database. All right, so the next slide is just a, sort of, we can click through this also. If we don't know how LLMs are doing what they do. That's just a fundamental problem that we have with this type of technology. So when you draft a contract, when an associate in the firm drafts a contract, you can ask them, well, why did you exclude losses from the indemnity clause? Did you want to add losses? And you should be able to have a dialogue about that. You cannot have that dialogue with the LLM. You can ask it to show its work, but that's often a post hoc rationalization and not always particularly trustworthy. But this is a little experiment that I did, redlining two versions of the same prompt that I put into GPT-5 within 10 minutes of each other. And it spat out two clauses that were similar but different in quite significant and substantive ways. One of which is the inclusion of losses in an indemnification clause. If you've ever negotiated one of these clauses, that's a big deal. Whether losses as opposed to just like third-party damages and claims are going to be included. You don't know why. And if there's an associate that you assign the task of drafting this agreement to, like you're never going to know. They're not going to realize what's going on. So the fact that different results come up in different with different queries virtually simultaneously is something to be aware of. Okay, next slide. I won't dwell on hallucinations. We've heard about those. We all understand. Even ChatGPT made me a nice image about its own weakness in this regard. Next slide. The black box problem is really just a problem that we can't explain why clauses are written the way they are, which makes negotiation difficult. And this is why it's so important, I think, to teach students the fundamentals, not just of drafting style, but also the substance of what they're drafting. Because at some point, until we're in the age where AI contracting agents just negotiate with each other without any human intervention at all, which is probably coming, but still several years away, humans need to understand what's going on here. The next slide is really just a bit of an analysis that I did that I won't go through because we're running short of time, on like how contract drafting is actually different in a qualitative way than other types of legal drafting that we use AI tools for. And my contention, and I'm biased because I do a lot of contract work, is that contracts and other operational documents are much harder for AI tools to do well than things like memoranda, where the precise wording is less important. Persuasive documents, explanatory documents, the choice of words you can use extremely and very and somewhat, in ways that are not precise, and it doesn't matter that much. But with contracts, where you're using defined terms, it's critical that the terms are used consistently throughout the document. And it's like software code, which AIs are quite good at generating. Anyway, I'll just move on to the last piece of my talk, which is the exercise, or that recent exercise that we've done in my class to try to compare like what's going on and teach students how to use these skills or how to use these tools. Okay, so the next slide is let's see. Yeah, okay. So again, this is just a repeat. These are the things that we'll be covering in the class. First lesson is literally just the very first one. Okay, so we can move to the next slide where I create a hypothetical, and the hypothetical, is just here. We've got an inventor. So, we both, Daryl and I both like IP. Cake. So she's invented a machine that puts sprinkles on cakes in a structured way. She wants to license it to a large bakery company. She wants a non-disclosure agreement, right? Simplest form of agreement. Okay, so what do? We start with this clause to define confidential information. So we go to the next slide. Um, in my case book, right, I've got a sample non-disclosure agreement. So I ask them to take that, like as if they're at a law firm, my case book is their firm's database, stick it into the, stick it, um, draft a definition of confidential information using the example from the casebook. Like this is non-AI assisted. You just do this. Okay, then in the next stage, this is the next slide, we, we talk about how you would prompt the tool to do the same thing. And so, if you click here, we talk about prompt engineering. Here's Martha. And this is the prompt that I use to create this image of Martha. So what happens next? They create their prompts. We talk about their prompts. Next slide, we input the prompt into the tool, and we crank it, and something's going to happen. And we talk about the clause that the tool generated based on the prompt and how similar it was to the one that they wrote by hand using the example in the textbook. Okay, so the next exercise on the next slide is now we're going to use Law Insider. And by the way, I saw somebody mention Spellbook's free educational account. Law Insider will also give you a free educator's account, so the faculty member and all of your students can get access to this tool. So we're going to copy the clause, like the handwritten clause, and we're going to see what comments Law Insider gives us about our handwritten clause. Then in the next step, we're going to have Law Insider critique the clause generated by the general purpose LLM, your Chat GPT. And it's fascinating. These AIs, they have no trouble critiquing each other's work. The thing that we found in these steps is the critiques are so long. We're just talking about the definition of confidential information. You can get 4 pages worth of commentary. And so one of the things that I'm trying to teach my students is how to limit this fire hose of information. When you can say, give me your comments in 200 words or less. And then, the things have to constrain themselves. Okay. The next exercise is we switch sides. Like when you wrote the clause, you were representing Martha. Well, now, the LLM is going to represent the bakery company, the recipient of the information. Let's see what comments it gives then. And then the next step is, same thing. We're going to see how Law Insider does, now representing the bakery company. And then the final step is we're going to do a red line, what we're going to send over to the other side. So the students have to pick which changes they think are important enough to negotiate, because the tool is going to want to change everything. And so we try to be selective because, again, we're literally just negotiating a confidentiality agreement. We can't spend all day. We spend a 90-minute class just on this exercise. But in real life, when you're billing, you can't spend that long. You've got to understand how to do this efficiently. So I don't know what the result has been. One nice thing about Law Insider is they're a small company. The head of this group is actually going to come to our last class so that he can ask the students what they thought about the product. They can give him feedback, and we're going to be a little bit like a beta testing site for this thing, which I think is kind of cool. It's very early days, so you can still do this kind of stuff. And anyway, that's it. We can move to the last slide. I just say goodbye. And so thanks a lot. And I really look forward to hearing what everybody else has to say.
Thank you so much, George. That was amazing. And I'm getting lots of requests for the slides, and we will send those around to people after the session. So we solicited for some lightning rounds, so just like 5 to 7 minutes per person. And these are the brave souls who volunteered. So I'll kick it over to Cynthia Dahl from Penn Carey Law at the University of Pennsylvania.
Thank you. It's delightful to be with you all. No pressure following those incredibly detailed presentations. And so I am not as far along in full disclosure as any of the three presenters from before, but for any of the rest of you on the call that are sort of tentatively, cautiously starting to wade into the waters of AI, I have a story for you of something that I tried in my clinic that I thought was interesting and sparked some pretty good discussion and some good learning among my students. Okay, so similar to everyone else, we are not allowed to put any of our confidential client information into any of the AI tools that we have licenses to use at this point, and so I'm limited right now to using AI tools in simulation only. We also do an interview simulation at the beginning of the semester, and so I thought this was a good place to start. So generally, of course, I assign readings as everyone else does. I give them a pretty detailed scenario of the person that they're going to be meeting with, and then traditionally we've hired an actor to come in and play the role. They have more information than the students do, and so then that sets up some good information exchange where the students have to discover and unpack some of the information that is secret to them at the beginning. So what did I do to try to incorporate AI into this process? Well, I told the students that after they finished the readings and they were preparing for the interview simulation, that they should do a full outline as they would have done in any other semester. And then I told them that I also, this semester, wanted them to pick an AI tool, and they have exposure to several, but I didn't limit them to any of the tools. I said, pick one tool and make your outline better in some way. And then I had them upload their original, their prompts, and their results, and then I gave them feedback on that. Then at the end of the interview, I had them do a little reflection about the whole process, and two of the questions had to do with using AI, and I asked them if the way that they had used AI was helpful to them or not, and then now having finished the interview, if they would have used it differently. And then we had a case rounds share out where everyone got the chance to share their prompts, to share their results, and then to talk about anything that they thought was helpful. So what I thought was useful about this process actually is that by and large, everyone tried to use an AI tool in the way that you would expect. You know, they uploaded their outlines and they said, make my questions more concise, or make my questions clearer. And by and large, they did not get good results when they did that. Also, several of them used it to teach them something about an area of the law. I teach the IP clinic, and so many of them are not yet familiar with patent law. And so teach me something about disclosure or teach me something about patent law. And by and large, they got some pretty high-level answers, helped the students that had never had patent law, but was not really that helpful. But what came out in the class discussion that I thought was really interesting about doing it this way was that the students that got good answers were the ones, to go back to what Catherine said, that gave the AI a role, that gave the AI context, basically uploaded the chapters that they'd had to read and uploaded the simulation documents that I'd given them, asked a specific question about how to make it better, and stated the form in which they would get most relevant results. And the two exciting uses that I thought came out of this semester's discussion were one student who said, here's all the readings, here are my goals, which include making this potential client feel comfortable and to be able to share all of their information with me. Look at my questions and give me feedback on how to redraft the questions, how to order the questions, what new questions to ask to meet my goals of making this client feel comfortable and getting more information. And that outline was so much better than what that student had originally prepared and really taught that student about how to change it next time. That I thought was a cool use. The second one was I had an LLM student who doesn't have the facility with English enough to chat. And she basically said, here is what I'm thinking about the beginning of this interview. Please make this more warm, welcoming, chatty, American, like added these other sorts of adjectives to it and got some ideas about how to change her script. So we're definitely really just at the beginning of trying to experiment, but I found that at least bringing the AI tool into the case rounds was helpful, and it did sort of supercharge our discussion and give them some things to think about in terms of their prompting and in terms of use. Oh, and one final thing I want to actually reiterate. The students that used Harvey came out with really, really, really long results, like 70-page results. And so definitely +1 to George's recommendation to leaning into that, stating what format the proper results should be in, limiting the length and the focus was something that we learned.
Thank you so much, Cynthia. I love this exercise, and I'm trying to think I might incorporate it at the beginning of my semester next year. So really appreciate that. I'm going to turn it over to Jonathan Smith from Washington University in St. Louis School of Law.
Hey, everybody. Thanks for the great longer presentations, and Cindy as well. And I also have some trepidation. I feel like this is more the junior varsity version, but I'm going to do it. So we have a legal tech week here each fall, and in connection with that, did this seminar this fall for the first time, sort of about exploring Gen AI tools in startup practice. And let me go back. So the setup, really, I was trying to think of two use cases that I thought might be helpful. One was interviewing practice, just to like have something that might bounce back ideas that are questions that would be different than what you expected. Doesn't matter if they're correct, so I wasn't as worried about the accuracy. And then the other was just kind of prompting additional ideas when we don't know what we might be missing in a document. So I was trying to get at those two things. The background is they've already done a scenario for a Missouri LLC company called Bengal Bat. It's not as good as Spaghetti, but it was the best I could come up with. And it's a couple of founders trying to make a better baseball bat and also support youth baseball. And the scenario here was we fast forwarded to a year later. Sarah, who's really the scientist in the team, wants to leave and start a different venture. She signed a technology assignment agreement around formation time, but doesn't have a forward-looking invention assignment agreement. Once, she has a $5,000 loan outstanding to the company, and Mike wants to bring in someone else. So the idea was to think through a departure scenario that might have some complexity to it, especially around the IP. And then the students were asked to use a Gen AI tool of their choice, a common, just open platform, assign it the role of Sarah's attorney, upload the operating agreement they'd previously drafted, and negotiate a separation and release agreement, half of the class with cooperative opposing counsel and half with an adversarial one, and just trying to test out what kind of responses we could get. So the role assignment, like I said, part of the test was for students to be able to frame the legal scenario well enough for the AI to respond usefully. And I think that was helpful. Some of it was to work out how well can these tools work within the context of an operating agreement that we gave it. And so that was kind of an important idea. The tone variation was interesting, not least because we wanted to be able to test out, how often, in my experience, these tools, it takes 3 or 4 iterations before they kind of figure out the level of conversation I want to be having with them or the kind of tone I want to have. So working at that skill. And then finally, kind of drafting and validation. We asked the AI to draft the settlement agreement just cold. And as George pointed out, it wasn't very good. We also then uploaded it to Westlaw's co-counsel feature to just review the document and see how it did. And so that was kind of the nature of the exercise. Some stuff we learned, the pattern matching does spot issues. It raised questions the students hadn't thought of, and I think that was useful just as a prep tool. The document grounded negotiation, it was pretty good, but sometimes it was flawed, and some of the conversations seemed non sequitur, and so that's an opportunity to learn how to pivot about the unexpected, but also I think expose some of the limitations of what the tools can do in terms of human-human interface, at least the ones that are commonly available. The difficulty calibration was interesting. We found even the hard ones were a little too nice and too eager to agree, and that was, I just thought, an interesting phenomenon. I thought it was a good counterweight to my students who often dig their heels in at everything, and we can never finish the exercise. But nonetheless, that was an interesting thing I noticed. The drafting and validation, the settlement agreements drafted were missing key terms. What was more surprising to me that the co-counsel, at least, as of last fall, had trouble accurately reading the agreements. It were proposed terms that were already in there. And it was helpful, I think, for the students to see that this is, even something that's meant to be legally, more trained and bespoke was still making mistakes. And so that was an important lesson. And I think the thing that was most interesting to reflect on with everyone is pattern matching decision making, because it was a negotiation. At some point, the AI decided to agree to your terms, and what causes it to do that, and how is that different or similar from how we as humans or a client decide, yeah, that one's good, and what is the intuition that we use to make that decision, and how does something that really is trained to match patterns and create output decide, yeah, this one's good enough for me. Right. So that was, and I don't know the answer to that, but that was, I thought, an interesting thing for us to discuss. Yeah, that's all I wanted to share. One thing I would love to talk to anybody offline though is some of you have talked about Spellbook and Word integrations, and in my conversations with them, it's reading everything in Word even when you don't have the add-in opened, and that has given me some pause just from a legal ethics standpoint. So if some of you have gotten your heads around that, I'd love to talk offline. Sorry for the extra plug.
Thank you so much, Jonathan. That was great. Next up is Anu Vyas from the University of Massachusetts School of Law.
Hi, everyone. Can you see me okay?
Yep.
Okay, great. So first of all, thank you so much. I'm checking the time to make sure that I limit myself and am respectful of everyone's time. I want to talk about Darth Vader, and I want to talk about Luke Skywalker. I want to talk about the dark side, and then I want to talk about the Force. And what do I mean by that? What I mean by that is that I worry that on the one hand, AI can replace critical thinking. And to me, that's the dark side of AI, that students just use it, not very critically engaging with it. They just find something and spit it out. But on the other hand, I think that there is something to be said for the Luke Skywalker Ben Kenobi version, where you actually use AI to supercharge critical thinking. And so I'm really curious and thinking about ways to effectuate that. And one last framing conversation is that I think there's a real agency asymmetry, particularly with new students. So I found that a student who is drafting a contract for the first time and maybe they're confronted with a form on Westlaw, there's a power dynamic where the power belongs to the form and not to the student, because the student thinks, I've never done this before. Who am I to change anything? This was reviewed by lawyers with decades of experience. I am just some person, and I don't have any agency to go ahead and do anything about this. So let me just cut and paste. So with all that in mind, I want to talk about two micro experiments I've done. One is dealing with a wedding photography contract, and the second is an anti-case hallucination tool that I built using tools from the Free Law Project. So with regards to the contract exercise, the first day of class, I have a friend of mine come in and just play someone who's a wedding photographer. I don't tell the students that they're going to do a sample client interview on the first day of class. I just surprise them. And so I tell them, look, you have 20 minutes to come up with questions. We have a client coming in. This is a really experiential class. Have at it. Let's roll with it. Now, obviously, it's not a real client and the like, but they have to go ahead, they have to do the client interview, and then they're given the task of drafting a contract by themselves without using any forms. And so just thinking and really listening to knowing that they have to do that, they approach it, I think, in a different way, knowing that they're the ones who have to come up with the contract. Then I allow them to use, later on in the semester, I allow them to use forms. And so then they can revise it. And then finally, I allow them to use, several weeks later, I allow them to use generative AI tools and then compare and contrast. And the feedback I've gotten from students is, just it's great to see the progression because that way they can see how they might disagree with what some of these models have come up with. And then also they're in a position to better critically evaluate what works and what doesn't work. So I found that that has been a fun exercise that students enjoy to build confidence. Second, I spent about 3.5 weeks over the summer building a tool called, it's a free tool to check for case hallucinations, and it's called isthiscasereal.com, which I'll drop in the chat. And I worry about using legal research and obviously case hallucinations, but people just using it to say, I don't really need to, I'll just find something on uh, Gemini and then I'll throw it in this tool and then I won't even think about it. That worries me. That worries me. But at the same time, I do think it's worthwhile to have some free tool out there that people can use. I will say that don't share anything confidential and it's just to check for cases and the like. But I will put it in the chat and you can play around with it if you'd like. I will say that one last thing that I will say, actually uh, two very quick things that I'll say is that um, as in a transactional clinic setting, I should admit that the terms are very awful, and I actually need to change those terms of service and privacy policies. So please don't look at them. And now everyone's going to look at them, and I'm going to feel terrible, and you're going to see that they're absolutely awful. So I deserve to be called out by putting that into the universe, but it's just something that I'm aware of, and I'm trying to get to it as soon as I finish all this other stuff. But I do think, and the last thing I'll say, I think this entire exercise is helpful because it really goes to the foundational idea of what a lawyer is. What's a business lawyer do? And I don't know if Praveen Kasuri is on here, but Praveen Kasuri from UPenn has this great article that I actually assigned to my students in intellectual property last year called Beyond Gilson, The Art of Business Lawyering. I'd recommend you check it out. I think it has a lot to do about how we reconceptualize this brave new world of lawyering. Thank you all.
Thank you so much, Anu. That's amazing, and I'm definitely going to check out the article. We have one more presenter today. That is Robert McKenzie from NYU School of Law, and I'm just going to load up the slides and put it in presenter mode. All right, Robert, take it
Great.
away.
Thanks, Catherine. So I'm going to keep this short and quick and give you one use case that I think, and hopefully you agree, puts you into the Luke Skywalker territory. It's not going to revolutionize what you're doing, but it gives you an opportunity to experiment and have your students start doing this in simulated work, but also in client work. And this is benchmarking and thinking about how we can use these tools in a way that enhances outputs as opposed to replacing workflows. So for context on how this works, and why do it. As part of the students' work in the clinics that I'm working with, which I think is a common experience, it's inevitable that they have and will run into contracts that they haven't thought about or seen before. And so to provide them with a framework for approaching this kind of scenario, which is common in the transactional practice, I had them undertake a benchmarking assignment. And then at the end of this, implemented and deployed some AI tools to enhance the scope of the benchmarking task, and also give them some opportunity to test their own thinking. So benchmarking is precedent comparison. In practice, I would do this kind of thing in my capital markets practice, preparing prospectuses, thinking about disclosure, and in contractual negotiations. The reality is parties often appeal to what is market or what has been agreed to by comparable peers. And being able to confidently engage in that discussion is valuable, and giving the students an opportunity to participate in that discussion, I find really valuable as well. So how it works is for a particular contract. So I've done this with website terms of use, service agreements. You can sort of pick and choose whatever you like. It could also be done in a litigation context or a memo context. Students choose 3 or 5 contracts, and so they have to go and undertake the task of thinking about what a helpful comparator would be, and then locate and identify them. And we spend time thinking about using IntelliGeyes, discussing the limits that George mentioned about pulling down public company contracts, the reality that they're already pre-negotiated and it's a limited scope, as well as other resources they can go and tap into. And then they do the manual task of reviewing and analyzing and creating a Word or Excel grid where the columns are the individual contracts and then the rows are categories of terms that they've identified. So once they have this first draft, we have a meeting, we discuss what their thoughts are, whether they found this helpful, how they think they might use this, and where they need to make revisions in order to actually improve the utility. After they've done that first round of revisions, so now they know how to do the task, they have some kind of a framework for thinking about getting up to speed in these kinds of negotiations. I have them use at least one AI tool if time permits. It's great if you can do this with two to compare how they handle this task. And when you're at that stage, you have have the students upload the grid that they've completed, the precedents that they've already analyzed to supplement and populate that grid, and then 3 or 5 or pick your number of additional precedents that you would like to add into the task, and instruct the tool to give you a prompt that would allow it to complete the task that the students have already done. The benefit of this is you get to see firsthand a comparison between the student work product and what they've done, and then what the tool is going to give you. And so, from a service perspective, why I find this helpful is one, it allows you to cover more breadth. It gives you more breadth to this kind of analysis. From a pedagogical perspective of putting this exercise in the AI use at the end, the benefit is you still have some control over the students doing the deep thinking that goes into contract comparison and analysis, and also formulating this grid to structure their own thought process. So, Catherine, if you wouldn't mind taking us to the next slide. Just as some highlights on why I like this approach and how I've found it helpful. So I've mentioned the deep learning and student-led review, and I think this is a key part. So part of the focus of implementing these tools in the clinics that I'm working on is thinking about when we put them in. And to some of the commenters who have called this out, if you let students run to it right away, sometimes they lose sight of the entire task. They skip the strategy and brainstorming phase. So I think when you're developing these tasks, whether it's one that have been discussed today or others, timing is really important. Now, I'll mention one caution about this particular use case for those that are thinking about it, which is to Catherine's discussion of AI tools. They're not designed to be search and retrieval tools. And this task is a good way to really highlight that. The tools will tend to want to summarize provisions that you ask it to pull out of contracts. With careful prompting, and there's differences between the tools, you can get to sort of a copy and paste and full extraction, but it's not perfect. And so as you experiment with this, I would encourage you and caution you to be very careful about what you're looking at on the back end. It certainly doesn't replace the task of reviewing whatever contracts it identifies as having similar terms, but it gets you through the stage of an initial review and identifying terms and identifying where there's gaps, and gives students an idea of different toggles they might want to use in their own drafting. And just to mention a few additional piece, some of these tools have a vault function, and I would encourage you, if you haven't used them, to experiment with that. So Harvey has a vault function where you can upload, it's now I think 10,000 documents, and allow the tool to hone its focus into that data set, almost like a grounded type approach. Protege has this chat, you can accomplish similar outcomes. That tool paired with this exercise is very helpful. And I think generally, as we think about the use cases that the firms are using, being able to train a tool or at least have it limit its access to resources and sources that you trust is one way to get over some of the concerns that I think many of us have about using these tools. So that is my one use case to offer to you all, which is to experiment with benchmarking and really allowing yourselves to cover more ground than you otherwise could in the time you have. And one last plug before I hand the mic back over to Catherine. May 6th, after the AALS Clinical Conference, we will be hosting the Transactional Clinical Conference at Lewis and Clark in Portland. You can expect a registration link in the coming weeks. There will be ample resource sharing happening at that conference, whether you're able to attend in person or not. So keep an eye out for that and look forward to seeing hopefully many of you there.
Thank you so much, Robert. That was great. Let me see. I have one more slide. So we got a couple of questions in the chat, and I will just go ahead and throw those out to the panel. But if others want to chime in, I think we have like 64 people on the call. So I hope this doesn't devolve into total chaos, but I'll do my best. So the first question that we got, and I can stop sharing, is I have been doing this more with access to justice providers. We do put in client information, but have paid versions that claim not to be storing information or using it. Is that enough to feel confident in it, or do people feel like more is necessary? We stress on the panel that we shouldn't be sharing client information with AI. So folks just wanted to take a temperature check on that. And I can start with that. My students just don't have access to those tested models yet through school enterprise accounts. So I am really stressing the not putting confidential information in. I don't feel confident about ChatGPT or Claude, keeping that safe. We are rolling out Harvey, and there I think I probably will feel comfortable with it. I've been talking a lot to our tech people and to the administration, and I think from my perspective, the risk typically is pretty low with my clients, and other, law firms are trusting it. So I think we feel pretty good about it. Do others want to weigh in?
Yeah.
Go ahead.
No, go ahead. You go ahead. Go ahead, please. Go ahead.
I was just going to say, when talking, I do think it's important to remind clients that their conversations with these models are not privileged or not work product. They don't have work product protection, and they're not subject to any duty of confidentiality.
Totally agree with that.
Yeah, I was just gonna do it. We just had some opinion, and at least I had to read it, but about exactly that happened. A client, at least on the news, to affirm a judge said it's not confident, it's not privileged, even though it should be. So that's an issue. But I was going to say, I think even the enterprise accounts still should look at that. One of my students brought up is says if you just go into an LLM, how do you extract it and delete it? And the answer I had is, I don't think you can. So it's one other reason why you probably shouldn't use confidential information of your client information in the system.
Yeah, and I'll add one more in here, which, if any of you were at the Mid-Atlantic Clinical Conference last week, you would have heard Celia Bigness, who's on the line, discuss this. But be aware of what your clients are doing as well. So your thought should not only be on what your policy says at your law school and your clinic, and also what the terms of conditions say for the tools you're using. But there's been some very startling examples from clinicians across the country on identifying that their clients are using it without telling them, and taking the outputs that you give them and putting them through various tools or forwarding them into places that jeopardize their own right to privilege. So you might want to build into your own playbooks, having a discussion in the intake process about what the parameters you expect on both ends will be.
It's great advice. Cynthia, do you want to say something?
Yeah, to the question, University of Pennsylvania characterizes the clinic work like all of the HIPAA protected information out of the health system. And for now, they're saying absolutely we don't trust any of the tools yet. And I think I would just add, because we're the IP clinic and we do work with a lot of UPenn technology, whenever we're thinking about something that might be patentable or protected by trade secret, I'm extra careful about that. So for the foreseeable future, we're not putting anything in any of the AI tools. And then to we had sort of an amusing story last semester about a student client's use of AI. They basically created their trademark logo through AI, but if we asked them straight up, because we had done a reverse image search and found something very similar out there, actually, that one of their competitors was using, and we asked them straight up, how did you come about designing this? And they said, oh, well, we designed it. I said, did you use an AI tool? Well, sure, we used an AI tool, but we designed it, because they were thinking to themselves, they put in the prompt, and and so I think you have to be even really very careful when you talk to your clients, because they will still think that they are the authors, even if they're relying on the AI tool for some part of it.
Yeah. Agree. The second question that we got is really for Daryl. And this question is, how the heck did you accomplish the avatar, whatever you want to call it, bot situation? If you want to say a little bit more about the actual steps you took to create that, I think people would be grateful.
Oh, well, I'm I programmed like maybe 30 years ago, but this is all non-programmer. You go DID Studios. Like it could send me offline. I can give you a link to it. And they have these avatars. I've been using these for like years on other things, and they use it a lot for customer service. That's what they're trying to folks to use it for. Where they put with where they're trying to market it for customer service, where you put the information in, and so it's just an idea I had to use it for this particular process. But I'm happy to talk to anybody about it. It's very simple to do. Yeah, I mean you can. I'll use the Matrix analogy. You can upload the helicopter or whatever to Neo or Trinity, and you just load it up there, and the system will operate it for you. So no programming necessary. You just pick the avatar you want, and it'll do it.
Great, thank you. I challenge everybody to go ahead and create an interview bot this summer. Any other questions? If anyone wants to raise their hand or plug into the chat, happy to stay on for a few more minutes. But otherwise, that's it. Thank you all for joining us. It's been great to, dive into this stuff. It's a brave new world, and we're all learning and we're all making mistakes, and it's good to be here with you. Jesse, you have a question?
Yes, thank
Go
you,
for it.
Catherine. Let me see if I can get my video on here, be a little more social. Fascinating discussions. Thanks to you and all the other panelists for your examples and thoughtfulness. I guess I would love to hear from anyone how you're thinking, not just on the benefit side of the equation, as it were. So here are some instances where there were some benefits to the students from the process described, but also the cost side. So each use of the tool involves, quite a bit of resource usage, for example. So how are you thinking about how beneficial a use case must be before it outweighs the costs that are associated with that use case?
Anybody want to jump in on that one? I'm happy to. I mean, I have not done that calculation for sure, but it's something that I bring up in class so that we discuss it. And I pulled an op-ed from the New York Times. You may have seen it about data centers being built across the Southeast and what that's doing to communities of color, especially. We talk about that. We talk about the realities of our clients' lives and how they are using ChatGPT, free ChatGPT with all their personal information. And so we're developing a project where we're coming out and doing training for our clients on how to use it more effectively and safely. We talk about who is actually building these products and how they do or do not represent our clients and even ourselves most of the time. And so just general discussion in the class about keeping these things at front of mind, and also what the role of the lawyer is with respect to advocating for regulation in this area. Because I think, one of our clinics' use is probably, less than a quarter of a drop of a bucket. But altogether, advocating and having one voice is more powerful. So just thinking about the role of the lawyer in that side of it.
I would say, just to echo, on the one hand, I think I don't, maybe I am uncomfortably comfortable with like being implicated in the larger energy problems and those problems while talking about them, but feeling like without totally opting out of a system, I need to do some work with this and training with it. I think the uses or the cons that I think hard about are, will this impact or stunt critical thinking skills for my students? I find that the tools, in large part where they're useful to me, require my knowledge to get them to where they're actually useful. In other words, like I spot six things that I think are wrong before I find. And so to the extent that my students are not aware of the problems that I see, I'm worried about short-circuiting that process and trying to find ways to make them aware of that issue in that process, including sometimes just letting them see my work with it, so that they're not thinking, it's not just does it hallucinate or not, but it's also like it can't decide, it doesn't have your judgment, it doesn't have your experience to know and so to that extent, wanting to make sure I'm not short-circuiting that process for them.
Anyone else want to jump in? I see no hands. But yeah, happy to continue that conversation separately, for sure, because I think it's really important. And when I raised it in class this past fall semester, the students really weren't thinking about it at all. So yeah, definitely part of the conversation.
Thank you again.
Yeah. Any other questions, use cases, anything else? No? All right, I think we'll end it there. Thank you all so much, and looking forward to seeing you all in Portland for those who will be there. Thank you.